And we smiled. So the judge then set forth very detailed procedures about how we were going to use classified evidence in our case. He ordered that we could designate up to 3 attorneys on our team to get security clearances. He ordered the government and the plaintiffs to come up with a protective order that would be used in the case. So we then go to the process of the application for security clearances, which was great fun, because we needed not just a top secret security clearance, but what we had learned about this case, this is a whole nother lecture, is that there's a separate way that the government classifies intelligence documents. And those documents, this document was also designated what is called an SCI document, a sensitive compartmented information document. So not only was it top secret, but it was an SCI. And SCI documents can't be kept, like, for example, in a judge's safe in his courtroom, like other classified documents, but they have to be kept in SCI facilities, what is called a SCIF. And a SCIF is an alarmed facility with no seams on the walls. And we spent actually the first couple of months in our litigation arguing about where the document should be kept. The government would go to the district court judge in Oregon and said, we're going to take that document from you. The judge would say, no, you're not. And the government would say, well, we need to keep it in a SCIF. And the court said, well, where's the SCIF in Oregon? And the government said, well, it's in the FBI's office. And we said, wait a minute, we sued the FBI. They can't have the document. So they had to transport the document to Seattle. I mean, there are, anyway. In any case, even after we got these security and clearances, there 2 of us got top secret and SCI security clearances. Another story about being interviewed by an FBI agent with my pictures of Cuba on the wall. That was fun too. But I got this clearance. Nonetheless, the government's position has been, we don't really care if these guys have these clearances. The bottom line is we're not going to release this document. That really has still been the position of the government. The court then held a hearing last June in which it was an order to show cause as to whether the government should be held in contempt for refusing to cooperate in terms of drafting a protective order in the case. And that hearing was held, but the judge did blink first in that hearing. I think the judge realized that once he ordered that the document be disclosed to us and the other classified filings be disclosed to us, the government would get an immediate appeal to the Ninth Circuit. They had tried to appeal his initial order on an interlocutory basis and as of right, but the Ninth Circuit dismissed that appeal. But the court said if they disclosed the document to us, he thought that they could get an appeal, and we think this judge wants to issue a decision on the merits. So he came back to us and said, file a motion for summary judgment to resolve this case, but don't use classified evidence. If the government responds using classified evidence, I'll disclose it to you. But let's see what the government does first. We filed our motion without using classified evidence. The government, in fact, did not respond using classified evidence. They simply responded by saying, number one, the non-classified evidence you filed isn't enough to prove your case, and that's it. We, the government, should win. The government never addressed the merits of the litigation in their brief. And we think part of the reason for that is because our brief, half the time, quoted Obama administration people about why they thought this program was illegal and unconstitutional. So we were kind of interested in hearing what they would say in court, but they didn't. In any case, that decision, or that hearing was held about a month or so ago, and that decision is pending, so we should get that decision anytime. We expect, and let me just conclude by saying this, that the issue of the use of classified documents under FISA will eventually be held by the Ninth Circuit and maybe one day by the Supreme Court. And we're hopeful, and we've seen this now in other cases, that as we move further away from September 11th, there have been recent decisions showing that courts have been less sympathetic to assertions of state secrets and national security. The Obama people are still asserting the privilege. There was an article in the New York Times and in other papers reporting that they have a new procedure for how they're going to review documents under the state secrets privilege, but it doesn't in any way change the way or the arguments they're making about the use of that privilege. So in our case up to now, and the judges repeatedly asked the government, have you talked to the people in the Obama administration? Is your position really what you're saying? And the government attorneys say we have spoken to the highest levels in the Obama administration, and we are absolutely making these representations with that authorization. But there have been some cases. I'll give you one example. Horn versus Huddle is a Washington, D.C. case by Judge Lamberth, who was the head of the secret court created by FISA and not known as a deep-seated liberal. But Judge...
Changed in recent years.
Yes, a little bit. Judge Lamberth issued a decision. If you want to read it, it's a 2009. I only have a Westlaw citation, 2610100. That was a Bivens action brought by a former employee of the Drug Enforcement Administration alleging that there had been wiretapping of him in Burma. In that case, actually, the court rejected the assertion of the state secrets privilege, and to deal with classified evidence, the court ordered that the defense or the plaintiff's attorneys get security clearances. The government responded by settling the case. That case is settled. But there have been other examples as well that the courts maybe are getting a little bit more willing to not just back off when the government screams national security. In the meantime, there is one other thing going on. Congress does have a law. There is a law pending in Congress about changing the state secrets privilege, although no one believes that that law is going anywhere at this point. So I encourage you to get involved in these cases. A lot of our pleadings are on the materials that you have. We're certainly, any of us, available to talk to you and to consult with you about handling our case, and keep reading about Al-Haramain. Thank you.